Hail there, legal warriors. Restraining orders. So many people are getting restraining orders, and there's 4 crucial mistakes to avoid if you get served with a restraining order. There's stuff you need to do, there's stuff you need to not do. So if you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm has been defending people charged with crimes all throughout Washington state for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now I'm just going to jump right into it. Restraining orders, what is that? Well, there's a pretty new law in Washington state which made it really hard on people called respondents. Respondent is the party that's being accused of violating some statute, RCW 7.105, or the petitioner, the complaining party, says, hey, judge, order them to not have contact with me, order them sometimes out of their own home, order them to do classes, order them to pay money. It's a whole bunch of stuff. But the main types of restraining orders are domestic violence restraining order, anti-harassment restraining order. There's also sexual assault restraining orders, and a couple others, stalking, 4 or 5. So, and although the public calls them restraining orders, under the law, they're called protection orders, right? The law calls it a protection order. The public usually says restraining order. It's the same thing. Protection, restraining, same thing for purposes of this video. So what are 4 mistakes to avoid? Well, the first mistake to avoid, I already mentioned in the open, is not doing anything, not filing a response. So the way a restraining order works is the petitioner goes in ex parte, that is one-sided, and fills out paperwork and says, the respondent is harassing me, the respondent has assaulted me, the respondent's stalking me, and it's all one-sided. And so the judge, and that's how it's set up, the judge looks at the petitioner's claims and says, yeah, if that's true, that qualifies under the statute. I'm going to restrain the respondent from contacting you and a bunch of other stuff also. And then they set a court date 2 weeks out for the respondent to appear and answer to the claims. And some people mistakenly think that they can just walk into court and just tell the judge what happened. And for most practical purposes, that is a mistake, because the judge already has in writing at that second date, the full order hearing, which is 2 weeks later, the judge already has in writing all the claims against you, respondent. And if you don't have your response in front of the court before court, where the court's had time to read it, right? If they don't have a chance to read your side, they're way one-sided against you, even more so than normal when that court hearing happens. And you might think that you have a lot of time to talk, and some court doesn't give you any time to talk. Some courts won't even hear your case unless you file a response. It's different in each court in Washington state, but Snohomish County Superior Court, they give you 5 minutes to talk, 5 minutes. And if you don't have a response, they may give you no minutes. They may continue it to make you file a response. Some other courts will let you go on and on and on, but you're at a huge disadvantage if you fail to file a response. So don't make that mistake. Number 2, what's the second big mistake that you could make regarding a restraining order hearing? Well, as a respondent, the second thing that you want to avoid is saying the wrong things in your response, right? You have to talk about what's relevant in your response. So look at the statute, contact an attorney if you can, but look at the statute. It's under RCW 7.105. It's a whole long statute. You can find that online, and read the definitions of what you're accused of, right? The definitions should also be mentioned somewhere deep in the paperwork you were given, but go ahead and take a look at it. You don't need to be a lawyer to read the definition and understand what the factors are the court is considering. So if you're a respondent in an anti-harassment case where there's like a claim you texted someone 100 times and that was harassing, you shouldn't talk about random things like they're a really bad person and they've also done bad stuff to me. That isn't really going to get you anywhere. You need to, in that case, potentially explain why your contacts were legitimate and lawful, why they were for a valid purpose, because the statute talks about for anti-harassment whether or not contacts were for a lawful or a valid purpose, because then maybe they're not harassing. Maybe that person owes you money. It's why you're contacting them so much, right? Something like that. We've actually had that case. where we were able to defeat an order because money was owed, money wasn't being paid, and somebody filed an order to try to keep from paying. And if you read the law, you can file the right type of response. As part of that also is you want to be careful to not admit to crimes when you file a response, right? Let's say you're accused of domestic violence. Well, and it says in the petition that maybe the respondent, hit somebody. If you file a response, I didn't hit them, I only pushed them. Well, a push is also a crime, and you may be opening yourself up to criminal liability because the police or the prosecutor, if there's one involved, they can get that statement, right? They can get that statement that you wrote under oath and use that against you. So you need to be careful about what you file, right? Moving on, mistake number 3 to avoid. Failing to serve the petitioner with your response. And as part of that also is failing to file your response with the court in a timely manner so the court actually has a chance to read it, okay? So the law says that anything the petitioner files, you're supposed to get, respondent, so you can read to see the claims against you. What most respondents don't realize is anything that you file in court in response also has to be given to the petitioner. And you don't want to make a mistake in how you give it to the petitioner. Typically, you're going to want to have somebody who's not you, who's 18 or above, serve the petitioner with your response, anything you filed in the court. That might be by email, that might be in person. You have to take a look in the petition. It's going to say on page 3 how they want to be served. There may be an email, there may be an address, something like that. But if you fail to serve the petitioner with your response, your court date's probably not going to go forward. It's going to get continued. You're going to miss more work, stuff like that. Also, if let's say the court date is Friday morning at 8:30, if you file your stuff Thursday afternoon at 4:30, is the court going to have a chance to read it? No. Why not? Because yours wouldn't be the only person on the calendar Friday morning, right? That there might be 10 cases or 12 cases, so you got to see if you can poke around online and find out what the deadlines are for filing things. Some courts have no deadlines, but a good rule of thumb that we think about is at least 2 days before the hearing, so there's a chance for the court to read what you wrote. So that was sort of 2 mistakes in one there. One is failing to serve the petitioner with your response, and the other is not getting it to the court in time so they have a chance to read it. So those are the first 3 mistakes. I think the 4th mistake people make is, it may seem like a throwaway, but it's not. It's not talking to a lawyer, right? At least talk to a lawyer to find out how this is really going to affect your life. Are there any legal defenses? Maybe you can hire a lawyer to do this for you. We have a professional writer on staff who helps do these because they're really complicated to tell your whole life story in a short amount of time. You also want to talk to a lawyer to see if you've been served in time, right? You have to be served a full 5 court days before the hearing. Otherwise, you're entitled to a continuance. So, you need to talk to a lawyer. It doesn't have to be us to find out, how big a deal is this? How is it really going to affect my life? What do they know about that court? What is it you need to know? Because it's usually a totally foreign area of the law. People are scared to death. If you're a respondent, you're going to be scared when you get this. And sometimes we can tamp down on it, or sometimes we need to elevate it if you're not taking it seriously enough. Because if you fail to appear at a hearing and you do nothing, the court can grant whatever it wants. And lately, I've been seeing more courts issue permanent orders. That's forever orders. And you don't want a forever order against you, okay? I've seen that a lot in King County Northeast District in Redmond. I've seen it a couple different places. So I want you to make sure you contact an attorney if you have been served a restraining order and you have you're a respondent and you need to respond to that situation. So I hope you found this video useful. If so, please like and please subscribe. More people get the help they need. More importantly, if you've got a restraining order matter, it's in somewhere in Western Washington mainly. Feel free to give my office a call. We'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.